Hello again. Civil society groups are taking government to court over the 350 Rand grant applications. They claim some of the new regulations are unfair and should be declared unconstitutional. These new regulations disqualify applicants who have more than 350 Rand. The activist groups claim the grant isn't enough to cover food and other expenses. For more on this, let's speak to Neil Coleman from the Institute for Economic Justice. Neil, good afternoon and thank you very much for your time. Thanks for coming out of an important meeting just to talk to us for a few minutes. We appreciate it here today on eNCA. What's at issue here? Can you break it down for our viewers?
Yes, so Dan, you'll remember that when the state of disaster ended, a new regime was introduced where new regulations covered people who had previously applied for the grant, now had to reapply under new dispensation. So you remember that before March this year, about 15.5 million people applied every month. And by the end of March, nearly 11 million people were getting the grant on a monthly basis. When the new regulations kicked in, government didn't have its systems in place in order to roll out the grant, so that people in April and May have not received the grant up until this point. Government has undertaken to roll out the grant this month, but we now hear that people's April payments will only be made in July and their May payments only made in August. So that's the first issue. The second issue is that a threshold was introduced, a new threshold of 350 Rand. If you had anything more than 350 Rand in your bank account, then you are disqualified. In addition, beneficiaries had to apply through quite complex online systems. You had to have access to a device which gives you access to online systems and provide all manner of information which had previously not been required. So the numbers applying actually plummeted from 15.5 million in March to about 8 million in April, and have slightly crept up since then. So there are two issues. The one is that government is plunging people into a humanitarian crisis by not paying out the grants in a context where those people are living below the breadline, are relying on the grant for food and are on the brink of starvation. The second is that the regulations themselves are unfair and in the view of our lawyers and the lawyers of the Black Sash are unconstitutional. The third issue actually is that government has provided a budget, National Treasury provided a budget only for 10.5 million grant beneficiaries, but government's own figures show that 13.4 million odd people have no income in South Africa, and over 18 million people live below the food poverty line. In other words, somewhere between 16 and 18 million people should be qualifying for the grant, but government has only provided for 10.5 million beneficiaries. Okay. So what DSD and SARS are doing is suppressing the number of people who can qualify in order to fit into this irrational budget allocation.
Yeah, then we have millions of people who need this money being excluded. So what are you, as the Institute of Economic Justice and your peers, now going to do? When is this matter coming up in court? What are the next action steps you are taking to try and get this matter properly addressed?
Yeah, Dan, so there are two legal processes. There's the application which the Black Sash has made, it's filed papers, and the respondents are various government departments, the DSD, Treasury, et cetera, and that has been made on a semi-urgent basis. We have also yesterday served a legal letter on the Department of Social Development and the Presidency to say that these payments must be urgently expedited. We've made proposals in a letter to the President today from the IEJ to say that what they need to do is to condone the payment of people in April and May. In other words, not go through the cumbersome and extremely slow bank processes, but rather accept that people have made these applications in good faith and that they have not been paid through no fault of their own, and to accept that they need to fast track they need to fast-track these payments. There are two processes happening. Fast-tracking of the payments is the one application, and the other application is to strike down certain aspects of the regulations, including this unfair means test, 350 Rand, and other provisions which make it extremely difficult for applicants to apply. So these processes, we hope, will be expedited through the courts. We're waiting for government to respond to these various legal letters, etc., that have been submitted, and then we will go through the court processes and hope that there'll be, these problematic regulations will be rectified, but also that government will come to the table to find ways to address these problems that are affecting not only the 10.9 million beneficiaries, but also their dependents, which means that up to 30 million people in South Africa affected by this failure to roll out these SRD grants. It's a real crisis.
It is a big one. It's a big crisis indeed. Thank you very much, Neil, for your time. That's Neil Coleman from the Institute for Economic Justice.